this week to hear from Brent Kavanaugh, to hear about his exceptional qualifications, his record of dedication to the rule of law, and his demonstrated independence and his appreciation of the importance of the separation of powers. Indeed, to protect individual liberty, the framers designed a government of three co-equal branches, strictly separating legislative, executive, and judicial powers. The framers intended for the judiciary to be immune from the political pressures the other two face. That is, so that judges would decide cases according to the law and not according to popular opinion. Now, 230 years after ratification, our legal system is the envy of the world. It provides our people stability, predictability, protection of our rights, and equal access to justice. But this is only possible when judges are committed to the rule of law. Our legal system's success is built on judges accepting that their role is limited to deciding cases and controversies. A good judge exercises humility and makes decisions according to specific facts of the case and, of course, according to the law. A good judge never bases decisions on his preferred policy preferences. A good judge also has courage, recognizing that we have an independent judiciary to restrain judges when that government exceeds lawful authority. President Andrew Jackson said, quote, "All the rights secured to the citizens under the Constitution are worth nothing and a mere bubble except guaranteed to them by an independent and virtuous judiciary," end of quote. Confirmation hearings for Supreme Court nominees are a very important opportunity to discuss the appropriate role of judges. As I see it, and I expect many of my colleagues will agree, the role of the judge is to apply the law as written, even if the legal result is not one the judge personally likes. Justice Scalia has often been quoted because he was fond of saying, if a judge always likes the outcome of the cases he decides, he is probably doing something wrong. I don't want judges who always reach a liberal result or a conservative result. I want a judge who rules the law the way the law requires. Judges must leave lawmaking to the Congress, the elected representatives of the people. Judges and justices have lifetime appointments. They can't be voted out of office if they legislate. Whereas if Congress legislates something that people don't like, then you can vote them out of office. That's why they're to interpret law and not make law. Now, some have a very different view of what a judge's role should be. According to this view, judges should decide cases based upon particular outcomes in order to advance their politics. But the American people don't want their judges to pick sides before they hear a case. They want a judge who rules based upon what the law commands. This is the reason why all Supreme Court nominees since Ginsburg have declined to offer their personal opinions on the correctness of precedent. Seeking assurances from a nominee on how he will vote in certain cases or how he views certain precedent undermines judicial independence and essentially asks for a promise in exchange for a confirmation vote. It's unfair and unethical. Indeed, what litigant could expect a fair shake if the judge has already prejudged the case before the litigant even enters the courtroom. I expect Judge Kavanaugh, in fact, it's my advice to him, to follow the example set by Justice Ginsburg and all nominees that followed her, that a nominee should offer, quote, no hints, no forecasts, no previews, end of quote, on how they will vote. Justice Kagan, when asked about Roe v. Wade, said the following, quote, I do not believe it would be appropriate for me to comment on the merits of Roe v. Wade other than to say that it is a settled law entitled to precedential weight. The application of Roe to future cases and even its continued validity are issues likely to come before the court in the future, end of quote. Senators were satisfied with these answers on precedent. So, senators should be satisfied if Judge Kavanaugh answers similarly. This is my 15th Supreme Court confirmation hearing since I joined the committee in 1981. 31 years ago, during my 4th Supreme Court confirmation hearing, liberal outside groups and their Senate allies engaged in an unprecedented smear campaign against Judge Robert Bork. As Mark Pulliam said in an op-ed over the weekend, quote, the Borking of Robert Bork taught special interest groups that they could demonize judicial nominees based solely on their worldview. Worse, character assassinations proved an effective tactic, nearly sinking Justice Clarence Thomas's appointment 4 years later. But he also said, continuing to quote, by confirming Judge Kavanaugh, the Senate can go some way toward atoning for shameful treatment of Justice Robert Bork 31 years ago, end of quote. Judge Kavanaugh is one of the most qualified nominees, if not the most qualified nominee that I've seen. A graduate of Yale Law School, clerking 3 federal judges, including a man he nominated to replace. He spent all but 3 years of his career in public service and has served as a judge for 12 years on the D.C. Circuit, the most influential federal circuit court. He has one of the most impressive records for a lower court judge in the Supreme Court. In at least a dozen separate cases, the Supreme Court adopted positions advanced by Judge Kavanaugh. The American Bar Association, whose assessment Democratic leaders have called the gold standard of judicial evaluations, rated Judge Kavanaugh unanimously well qualified. A review of Judge Kavanaugh's extensive record demonstrates a deep commitment to the rule of law. He has written eloquently that both judges and federal agencies are bound by the law Congress enacts. And he's criticized those who substitute their own judgment about what a statute should say for what the statute actually says. After President nominated Judge Kavanaugh, I said this would be the most thorough and transparent confirmation process in history. I say that statement even regarding all the discussion we've had this morning. It has proven to be, from Judge Kavanaugh's authoring 307 opinions, joined hundreds more, amounting to more than 10,000 pages. He submitted 17,000 pages of speeches, articles, and other materials to the committee, along with this 120-page written response to the questionnaire that the committee set out. These adds up to 27,000 pages of Judge Kavanaugh's record already available to the American people, and we received just shy of 500,000 pages of emails and other documents from Judge Kavanaugh's service as an executive branch lawyer, which is more than we received for the last 5 Supreme Court nominees. Every one of these more than 483 pages of executive branch records are available to any senator 24/7. I pushed for federal officials to significantly expedite public disclosure process under federal law so that all Americans have online access to more than 290,000 pages of these records right now on our committee website. In short, the American people have unprecedented access and more materials to review Judge Kavanaugh than ever have had for a Supreme Court nominee. And to support the review of Judge Kavanaugh's historic volume of material, I've worked to ensure that more senators have access to more material than ever. Since so much of the rest of my statement has been discussed this morning by what the Democrats have said, and I've answered a lot of it, I'm going to put the last 7 pages of my statement in the record, and I'm going to ask Senator Feinstein if she has more to say on her opening statement, and if she doesn't, I'll go to Senator Hatch. Or do you have
Thank
some?
you.